Okay, good afternoon, everybody. Sound check quickly. Can you hear me?
Good
Yes, we can.
afternoon. Yeah, we can hear you clearly.
Okay, wonderful. Yes, first of all, well done with your test 2 results. They were absolutely lovely. Lots of hard work went in there. I had a look at the practice quiz. There were over 700 attempts in total, okay, not just your class, full-time students as well, but over 700 attempts for the practice quiz, which shows that students really made use of that opportunity to prepare themselves. And the results reflected accordingly. So I'm very happy. I'm very proud of you. My colleague, Mrs. Kugangelva, has very kindly offered to upload the marks on the kiosk. So that will be happening now within the next day or two, saving me a little bit of effort there because it is quite a process uploading those marks on the kiosk. For those of you, which is unlikely, because your test 1 results were also quite good. For those of you who have at this stage now not yet qualified for the exam, only those that have qualified, you cannot write the makeup test to improve your marks. It's only if you have not yet qualified. There is a makeup test opportunity on the 19th of October. So you will be able to write. So if you've missed a test, if you missed test 1 or test 2, or for some strange reason don't have an average mark of 40% yet, you can write the makeup test. We only have 2 more weeks left of lectures. We've finished with companies. We've done everything we're going to do with regard to companies. Last 2 weeks we spent very briefly looking at close corporations. There was something else I wanted to say to you as well, but now I've forgotten. Okay, let's get hold of my slideshow. Oh, that's what I wanted to say to you. While the slideshow is uploading, I don't know if you've looked at your, but there was that one question where there was no correct answer. Not everybody got that question, but some students got that question where the qualification shares of a director, they have to acquire their qualification shares within 2 months 2 months was not one of the options. Some of you guessed 4 months and was awarded marks for that. Anyone that guessed somebody else or left that out completely, I did a manual regrade. So for those of you that didn't get the marks, I manually added those 2 marks for you so that nobody was prejudiced because of the mistake in the actual question. So some of you might, once your marks are uploaded on the kiosk, get a pleasant surprise that it's actually a bit slightly higher than your original mark that reflected on e-learning, just so that you are aware of that. Okay, so let's start looking then at close corporations. Just thumbs up quickly if you can see the slides. Okay, so a close corporation is similar to a company in the sense that it is also a business entity, which is a juristic person. So it has legal personality. And many of the rules and regulations pertaining to close corporations are similar to companies. So my approach with close corporations is to actually assume you know everything, because you know everything with regard to companies. And then I point out to you where and how close corporations are different. Just give me a second. Okay, I'm going to interrupt the class quickly. I want to just switch my camera on. Can you see me? I have a little angel here with me, who's my little bonus granddaughter. And she's just come in here quickly and she just wants to say hello to you. Say hello. Her name is Anel.
Hello, Angel.
Hello. Hi, baby girl. Hello, Anna.
Yeah. Tell them, where do you go to school?
St. George's.
She goes to St. George's.
Oh, beautiful school.
Yes.
Wow.
And she's going to be as clever as you are one day.
Yeah, she should be teaching.
Yeah.
Exactly. We want her to teach law as well.
Yes, one day she's going to be teaching law as well.
Sure.
Okay, I need to get back to my class.
See you tomorrow.
Yeah. Okay. Entertainment there before we carry on with close corporations. She's my little sweetheart. One day she's going to be doing.
She's cute.
She is terribly, terribly cute. I love her to bits. Okay. So close corporations. Close corporations is the little sister of companies, so to speak. The rules and regulations with regard to close corporations are a lot similar, but a lot less complicated than companies. Okay, your learning objectives, you can look at those. So a close corporation, as I've mentioned, is a juristic person. it has legal personality, exactly the same as a company. So the members cannot be held liable for the debts of the company, of the corporation. The debts of the corporation are the responsibility of the corporation. Important differences, however, between companies and closed corporations. So the big resemblance is that it's also a juristic person. Differences, firstly, in a closed corporation, a maximum of 10 members. Remember, in companies, we use the term member and shareholder interchangeably, but you don't have shares in a closed corporation. So you can never use the term shareholder in a closed corporation. They are all members. They have a member's interest. Does not have shares, does not have share capital. Also, that whole division of corporate functions that I've been getting back to over and over and over again, when we spoke about companies, the division between directors and shareholders. None of that in closed corporations. You don't have directors and shareholders. You only have members. And in principle, all members of a closed corporation are permitted to participate in the management of the corporation. So there isn't this division of between ownership and management. The members are the owners and the management. In principle, that can be varied. We will get back to that at a later stage. As I mentioned, the rules with regard to closed corporations, the law is a lot easier. It's a simple and flexible corporate entity that still has the advantage of legal personality. It's easy to register, and the management and decision-making requirements are simple and informal. There are no special resolutions, no and shareholding and all that difficult stuff that you did in Unit 8 of the study guide about members meeting. Don't apply to closed corporations. A lot easier to run. So when you register a closed corporation, formation of a closed corporation, there are two documents. Company, remember, we had also two main documents, the Memorandum of Association and the Articles of Association. With a closed corporation, the main document, the founding document, is called the founding statement. Founding statement contains important details like the name, the main business, the main place of business, and the details of the members, who the members are, and their respective members' interest. Founding statement is registered at BIPA. Then you can also get an association agreement. Association agreement is an optional document. So you don't have to have an association agreement in your closed corporation. Although the moment a closed corporation consists of 2 or more members, I would strictly advise that you do enter into an association agreement, but it is not a legal requirement. We will look at association agreements in more detail at a later stage. The association agreement is comparable to the Articles of Association in that it sets out the rules of management, the rules of decision-making, that type of thing. But more, we will look at association agreements in more detail. Important provision here, similar to the Companies Act, the use of the name of the close corporation. Like a company, a close corporation also has a name. And similar to the provision in the Companies Act, all official documents, notices, other official documents, bills of exchange, money orders, orders for money, goods and services, etc., that are signed by or on behalf of the close corporation must have the full name and registration number. The full name and registration number is not so noted. Then the person who signed this document is liable for, may be liable for an offense, so they can be fined. But in addition to that, they also incur personal liability for the amount of that document, unless the amount has been paid by the corporation. So you will recall there is a similar, almost identical provision in the Companies Act. Now, if you have a company, this is important. If you have a company and you decide that you would like to continue the business, but not as a company, as a close corporation, a company can convert. You can convert a company to a close corporation, subject to the following requirements. And all these requirements must be met. Requirements are, firstly, that the company at the time of conversion must have 10 or fewer members. And actually, I should put this bullet point first. That one should go there, because it's important that you understand that all the members of the company at the time of conversion must become members of the close corporation. So you can't have a company with 20 members and decide, well, you're going to convert to a close corporation and 10 of them are just going to disappear, not become members. You're just going to kick them out. That doesn't happen like that. All the members of the close corporation must become members of the close corporation, which means there must be 10 or less. If there's more than 10, you cannot convert, and all the members must qualify for membership. Who may be members or not, we will discuss shortly. So if you have a company that's got 10 or less members that all qualify, the company can be converted to a close corporation. Further requirements that upon conversion, the company must both be solvent and liquid. You know what that means. Furthermore, the external auditor of the company must be prepared to state in writing that he or she has no reason to believe that there is a material irregularity that has taken place, or that the necessary steps to rectify this have been taken. If your company complies with these requirements, it can convert to a close corporation. What happens? What are the consequences of the close corporation? Important consequence is that the original juristic person, the company, continues to exist, but now in the form of a close corporation. Best way to perhaps understand, explain this. You recently, like 10 minutes ago, you had my darling little bonus granddaughter saying hello to you. Now, her mother, my daughter, or her bonus mother, married my son-in-law, her husband, 2 weeks ago. So it's very, very recent and all still new and exciting and everything. When she got married, her name changed. She was no longer Marilisa Gerber, she became Marilisa Low. But she's still the same person. If she had owed somebody money before the marriage, that debt doesn't miraculously go away because she now has a different name. Similarly with the company, if it was Koromoro Pty Limited, and now it becomes Koromoro CC. Koromoro Pty Limited owed money to a creditor. That creditor can claim that same debt from Koromoro CC. So all the assets, rights, liabilities, and obligations of what was the company becomes vested in the close corporation. Any legal proceedings may be continued. Any acts done by or in respect of the company are deemed to have been done by the corporation. Personal liability of directors or officers that had arisen before the conversion. Let's say the company issued an order which was signed by a director, but it didn't have the correct name of the director on it, which means the director becomes personally liable for the amount of that document. Now it's a closed corporation, but the director still remains liable for that amount. So business as usual, but just under a different name. So who may be a member of a closed corporation? When we looked at the requirements, we saw that all members must qualify. So who may be members? You will recall that for shareholding in a company, there was no requirement. Anybody, irrespective of their age, could be a shareholder of a company. A company can be a shareholder of another company. A closed corporation can be a shareholder of a company. For closed corporations, however, there are some strict rules regarding membership. The general rules. There are general rules and then there are exceptions to these general rules. The general rules are firstly that all natural persons may become members irrespective of their contractual capacity. So minors may become members. All natural persons, but only natural persons. Only natural persons. So companies and other closed corporations may not become members of a closed corporation. Closed corporation can be a member of a company, but a company cannot be a member of a closed corporation. Only natural persons acting in their personal capacity. So not representing somebody else. Not Alicia on behalf of somebody else. These are the general rules. There are exceptions, as I said. So no juristic persons. Furthermore, a member's interest cannot be shared, which means a partnership cannot be a member of a closed corporation. If Mapenzi and Mr. Walters are in a partnership, and they want to become members of a closed corporation, Mapenzi Walters Partnership cannot have a member's interest. Mapenzi can and Walters can, separately in their own name, but not together as a partnership. So your general rule then, once again, natural persons acting in their personal capacity on their own, not sharing. There are, however, certain exceptions. First exception to the rule that natural persons acting in their own capacity is the exception that natural persons acting as a legal representative for another natural person. So let's say there is a child. My little bonus granddaughter, once again, her name is Zanelle. She's 5 years old. She can either be a member of a closed corporation in her own capacity, the member's interest can be on her name, or alternatively, her father, who is also a natural person, can hold it on her behalf. So then it would be Andrew on behalf of Zanelle. So a natural person representing another natural person. Natural persons in their capacity as trustee of a testamentary trust, not an inter vivos trust, provided all the beneficiaries of such testamentary trust are natural persons. Now, we haven't done trust law. You get two types of trusts. You get a trust which is formed, created in a person's last will and testament, which is known as a testamentary trust, or a person who is still alive can create a trust, which is then known as an inter vivos trust. In a trust, if you create a trust, there's the founder of the trust who appoints trustees, who manages the property of the trust on behalf of the beneficiaries. Now, you don't have to have studied trust law to be able to apply this requirement for membership. You must just remember it, because I will always give you sufficient information. I will not expect of you to decide on yourself from a case study whether this is a testamentary trust or not, because we don't do trust law. I will tell you, so-and-so in their capacity as trustee of a testamentary trust, or so-and-so in their capacity as trustee of an inter vivos trust. So you must just remember, testamentary, yes. Inter vivos, no. Testamentary, yes. Inter vivos, never ever. Testamentary, yes, provided that the beneficiaries are natural persons. And I will obviously also always tell you who the beneficiaries are. So if you see amongst the beneficiaries, there's a Pty Limited, that's not a natural person. But if it's Eleni, Renette, and Jackson, they are natural persons. So a natural person in their capacity as trustee of a testamentary trust. Exceptions for juristic persons as well, related to these first exceptions. A juristic person acting as legal representative for a natural person. Also, a juristic person in their capacity as trustee of a testamentary trust, never inter vivos. If it's a testamentary trust and the trustee is a juristic person, they could be, but there are further requirements, namely that the beneficiaries must once again be natural persons, and the beneficiaries must not control the trustee. So if the trustee is Walters Pty Limited and Sean is the sole shareholder of Walters Pty Limited, and Sean is also a trustee of that trust, then they will not be allowed membership of the closed corporation, because Sean is controlling the beneficiary is controlling the trustee. Any questions? No questions. Mr.
No
Mapenzi.
question.
Mr. Mapenzi's got his hand up.
Yes, ma'am. I know maybe the question might not relate, but then how do we define a trustee? Shouldn't a trustee as well be defined as a beneficiary, or maybe in
No.
terms of company law, they wouldn't be defined as beneficiaries? Because when we look at this new definition of beneficial ownership, it goes as far as looking at the founders or the settler, as well as looking at the trustees, as well as looking at the beneficiaries for the trust. But then I think that's defining maybe in terms of beneficial ownership, maybe in line with maybe with the regulations of the Financial Intelligence Act. So maybe it's something different. Maybe in terms of company law, then maybe it looks at it differently.
Yes, Mr. Mapenzi, excellent question there. The two concepts are related. They are related. You need to perhaps understand, as you yourself said, maybe it's not quite relevant because the definitions of beneficial ownership, you are referring to the definitions in FICA, the Financial Intelligence Act, which is a much more new act. It's a much younger act than the Close Corporations Act. When the Close Corporations Act was drafted, they didn't actually think of all these future implications, and that we might have a Financial Intelligence Act and have to prevent corruption and the purpose. You obviously know the purpose of the Financial Intelligence Act. I think to simplify it is that all these exceptions refer to natural persons at the end of the day. So it's somebody representing a natural person. One natural person representing another natural person. A juristic person representing another natural person. The underlying philosophy behind this is that only natural persons may benefit from close corporations. So to relate that to your question and the definitions in the Financial Intelligence Act, I think, should this ever be tested before in a court of law, how to reconcile these two pieces of legislation, I dare say the court's argument will be that the beneficial owner of the member's interest must be a natural person, not a juristic person. That's pretty much the best I can answer your question, but I think that is how it should be interpreted. So these definitions of trustee, you've got the founder, you've got the trustee, and you've got the beneficiaries. We're looking at who are the beneficiaries. And those beneficiaries, the people that are going to be benefiting, must be natural persons. I trust that answers your question. Does that answer your question? I saw you gave me a thumbs up there.
Yes, ma'am.
Okay. Any further questions? I must say my company class would not be nearly as enjoyable to teach if it wasn't for the questions that I had coming from the class. Mr. Mapenzi, not only Mr. Mapenzi, there are a large number of students that regularly participate in class. And I have said this before, I love how you relate the work that I'm teaching you to your own knowledge and experience that you have of business. It just makes for so much more interesting class to teach. Okay, let's carry on. So persons who qualify for membership, essentially natural persons. It may only be a natural person that benefits from a closed corporation. Two quick provisions in the Closed Corporations Act that you are acquainted with that relate to membership. I'm saying you're acquainted with them because we did this in company law when we were doing companies, when we were doing capital maintenance. Similar provisions in the Closed Corporations Act, namely that in the first instance, payment by the corporation for the acquisition of a member's interest. The related provision in the Companies Act was a company obtaining its own shares. Closed corporation doesn't have shares, there's only member interests, but a closed corporation may acquire a member interest in itself. What happens, before I look at these requirements, what happens if a closed corporation acquires a member's interest in itself? Remember, company buys its own shares, those shares are cancelled, they become authorized but unissued shares. In a closed corporation, obviously there needs to be more than one member to start off with for a closed corporation to acquire a member's interest, because there must always be at least one member left. Member's interest, which is acquired by the closed corporation, is then shared pro rata between the remaining members. So if there was two members, Alicia and Selma, and the closed corporation acquires Alicia's members' interest, Selma will then have 100% members' interest. If the members were in equal shares, Maria, Selma, and Alicia, closed corporation acquires Alicia's members' interest. That members' interest is then divided between the remaining members. So instead of having a third each, they will have 50% each. Quite simple. Requirements are also simple. There's no special resolution required. Closed corporations don't use special resolutions. They work on the basis of written consent. So all the members of the closed corporation must give written consent. And then, similar to companies, it must be solvent after payment is made. It must be liquid. And then a third one, the payment will not render the corporation unable to pay its debts as they become due. So it must be liquid at the time of the acquisition, and it must remain liquid. So it must be solvent, liquid, and after payment is made, remain liquid. So the acquisition mustn't negatively affect its liquidity. Granting of financial assistance by the corporation in respect of acquisition of a member's interest. Similar thing in companies, financial assistance for the purchase of shares in the company. Same thing, a lot easier. Same provisions as the previous one. Written consent, solvent, liquid, and remain liquid. That's it. So I've now covered units 18, 19, and 20 in about 3/4 of an hour. Quick. Close corporations is not difficult, not at all. And there are questions on close corporations in the exam, but the majority of the questions are from companies. Any questions?
Miss, I would like to confirm because I saw something about the auditor. So is it also a requirement that the CC should have an external auditor every time?
No, it is not a requirement. I'm going to go back to where you saw that. It was here with conversion. The auditor of the company must be prepared to state. So remember, it's a company that wishes to convert. And that company would have had or must have at the time of conversion an external auditor who must then make this written statement. The moment the conversion is completed, close corporations do not require external auditors. They must have an accounting officer, but it doesn't have to be a qualified chartered accountant like the requirement is for companies. So while the company still exists, there would be an external auditor who must make the statement. Once the conversion is completed, his job is done, and then they can fire him and replace him with an accounting officer.
Well noted. Thank you.
Okay, thank you for that. More questions? Mr. Van Wyk.
Good evening, ma'am. I just want to find out or to make sure, can a close corporation buy shares into a close corporation or be a member?
No.
Okay.
No, a close corporation, only natural persons may benefit from a close corporation. So a juristic person may not be a member of, so another close corporation may not be a member of a close corporation, only natural persons. Subject to those exceptions if they are representing a natural person, but they may not themselves benefit from another close corporation.
Okay.
More questions?
Maybe the last question that I have, it's quite a tricky one. I don't know if it relates because you, just like you are saying, if they are represented by a natural person, you find an example, a minor has a registered CC, but then maybe the representative is let's say the father. So meaning that sometimes some people would use their kids into registering these entities and maybe apply for tender, maybe for tender facilities. So maybe just looking at the line between representative or acting on behalf, as well as sometimes maybe this might be the beneficial owner, but standing behind the child. So, yeah.
Yeah, Mr. Mapenzi, once again, we're not talking specifically close corporations law at the moment, but rather discussing the fact that sometimes people are inherently dishonest. So a father who's a foreign citizen might register a close corporation, make his child, his minor child, who's a Namibian citizen, the sole member of the close corporation, and then apply for tenders and get tender, what is the word, advantages, because it's a so-called Namibian close corporation. I think that's what you're referring to. That's not something, unfortunately, that the Close Corporations Act can prevent. In terms of the Close Corporations Act, that father representing the minor child falls in line with the requirements for membership. That it is definitely a procurement issue. And when the procurement board starts looking at tenders, they should pick this up and say, hang on, what's happening here? Why is this sole member of the closed corporation only 5 years old? What is actually going on here? Who is actually the beneficial owner behind the scenes? That is a procurement issue. But in terms of the Closed Corporations Act on paper, there's nothing that can prevent that. Okay, lovely questions there. Any more? Mr. Van Wyk, is that an old hand or do you have another question?
No, it's an old thing.
Okay, wonderful. Thank you, people. Thank you for joining.
Thank you, ma'am.
We have actually covered all the work that we were supposed to do this whole week, but I do think we should have a class on Thursday, even if it's not a very long class, to just carry on a little bit. Then we can rather end the semester earlier than take too many breaks now. So I will see you then in class on Thursday evening. Thank you very much. Have a wonderful evening further.
Thank you,
Thank you
ma'am.
very much, ma'am.
You
Say
too.
bye to Anel.
Good night.
I will do that.
Thank you, ma'am. Good night.
Good night.
Ta-ta.